Our first case of the morning is State versus Scheidt. I'm going to guess the pronunciation. I may be wrong.
You're correct, Your Honor.
Oh, good. I'm glad. My college German came in handy. Each party will have 15 minutes to present their argument. Of course, if you see there's no one to rebut, you just have 15 minutes to present your argument without reserving any rebuttal time. The argument to be recorded when you present your argument. Make sure you come up to the podium, introduce yourself, and make sure you speak loud enough so we can hear you as well. And stay behind the podium so you don't move too much. We don't lose your job. Do not use the name of a child, minor, or victim during your case. Please use initials or some other designation like child, minor, or victim. With that, the court has read your briefs and ready to proceed whenever you are.
Thank you, Judge Stevenson. Your Honors, may it please the court, Andrew Karras on behalf of the appellant, Stephani Nicole Scheidt. We've raised 4 assignments of error in this case. I plan on addressing 3 of them this morning, working somewhat in reverse order, starting with the restitution issues, and then I'll speak to the evidentiary issues as well. But first, as it relates to restitution. So the sentencing order in this case imposes restitution in the amount of the difference in value of the vehicle from the purchase to sale. I would submit that that requires this court to vacate it on a number of grounds. The most important one, because I think it's the one that drives the remedy, is that neither the state nor the victim specifically requested restitution. Like any other constitutional right, the right to restitution is forfeited if not timely asserted. That flows from the Supreme Court's decision in the fairly recent Brasher case. And Brandenburg, that's an 8th district case that we've cited in our brief. The court specifically held that general statements about the economic loss experienced as a way of addressing the felony sentence factors, that's not enough to make a restitution request. Given that, and given that restitution awards, or the lack of a restitution award, is subject to res judicata principles, I would submit that the remedy here is to just vacate the restitution component of the sentence. That said, that's not the only problem with what the court did with respect to restitution. So setting aside whether, contrary to the Brandenburg case that I just talked about, whether economic loss as a sentencing factor is sufficient to raise a request for restitution. The court failed to set here, despite the extent of economic loss being in dispute. I'm just quoting from defense counsel's argument at sentencing. There's really no economic loss to any of these parties. And so when a defendant disputes the amount of restitution, the trial court must at minimum conduct a hearing on the issue of restitution, and that didn't happen here. Moreover, there's no amount of restitution specified. The trial court imposed a formula rather than a number. That's contrary to a number of cases. Some of the ones that we've cited in our brief are Purnell, Langston, Church, Castaneda, Downey. Those are from a variety of districts. Finally, there was no recipient specified. Well, that, on this record may or may not feel like a bit of a gotcha. It is a requirement, as we've recited in our brief, based on the way restitution was imposed in the amount of the difference in value of the vehicle from the purchase to sale, it is ambiguous how the probation department would effectuate that command, given that there were, based on the trial record, multiple purchases and sales of this vehicle. Again, I would submit that the remedy here, the restitution award, is precluded by res judicata because no party made a timely request for it, neither the victim nor the state. But alternatively, at a minimum, I think the restitution component of the sentence should be vacated and remanded for an evidentiary hearing. Okay. So, turning to the evidentiary issues, I'm going to start with the testimony of Aline Snellenberger. That was the witness who testified specifically to the transaction whereby Scheidt putatively sold the vehicle in question, the Dodge Ram, to Squared Auto. So the gravamen of the state's case is that Scheidt fraudulently titled the Ram from the victim to herself and then sold it to Squared. So I'll just start with the fact that this was a prejudicial admission. Other witnesses' testimony tends to establish that these transactions occurred and that they benefited my client. But Snellenberger's testimony much more directly demonstrates that Scheidt conducted those transactions. In fact, the ultimate one at issue, the gravamen of the state's case, again, that she sold the car to Squared Auto, she spoke directly to in a way that no other witness did or could. So we've cited this court's precedent in Bennett for the premise that Criminal Rule 16I requires a list of witnesses, not the disclosure of a compilation of documents from whose identity the state's witnesses can be gleaning. A case not discussed in our brief or the state's brief that walks that language back a little bit is the Peronic decision that's also from this court. That's 2019 Ohio 4305, which involved kind of an inverse situation where defense counsel didn't produce a single document, entitled, "Here's my Rule 16I list of witnesses," but what they did do is provide copies of subpoenas. And here, this court said that was good enough, even though the preferred method would be to provide, a list of witnesses contained in a single document. At least what defense counsel did in the Peronic case designated those people as witnesses and provided them to the state prior to trial. So I would submit that it's not a particularly close question in this case whether a violation of Rule 16I occurred in this case. The harder question from my side of the V, as I see it, is whether the trial court's remedy constitutes an abuse of discretion. So generally speaking, discovery violations are committed to the sound discretion of the trial court. They're allowed and encouraged to impose the minimum sanction that cures the prejudice. However, here, the trial court's remedy for this particular discovery violation did not cure the prejudice as defense counsel articulated in the trial court below. So what the defense got?
Number one, I guess, did the defense counsel below object to this witness's testimony?
Yes.
And that was my recollection. And then the court tried to cure by saying you can talk to this person, I recall, and have a chance to have a discussion with them. After they had that chance to have a discussion, did defense counsel continue their objection?
He did renew his objection at that point, and he did explain, what he would have done, if he had this proffer of testimony sooner. He said, well, I would have, used additional time to obtain materials impeaching or at least further investigating her claims.
And I don't recall from the record, did the trial court offer a continuance and say we can find you're not prepared, you have the witnesses, we'll continue the matter to let you have an opportunity to call witnesses?
He did not, and I would say this is, so before the discussion of whether this person was going to be called as a witness or not, he did, let the parties know, we need to finish this trial today. And then later on, the remedy, he said, was you get this, what amounted to a multi-minute continuance to talk to the witness. So I think it is true, and what's one of the harder points on this record is that defense counsel didn't specifically utter the word continuance when he made the objection to her testimony, but the essence of all of his objections to her testimony was that he needed more time to prepare for the effect of what she was going to say.
Counsel, what was the length of the multi-minute time period?
So what they say on the record is I'll give you 10 minutes, I believe, and there are timestamps in the transcript that reflect when they went off the record and when they went back on it. To my recollection, it may have been a little more than 10, just given the way trial happens. The jury has to go out, the jury has to come in, but it wasn't much longer than 10.
Okay, thank you.
So for all of those reasons, I would submit that the case or the judgment below should be remanded for a new trial on this issue. The trial court's remedy for curing the prejudice that they suffered by the surprise of this witness being called as a witness just wasn't sufficient to, again, cure the prejudice. Turning now to the other evidentiary issue we've raised with respect to allowing Ms. Johnson's testimony, comparing established handwriting exemplars from both the victim as well as Ms. Scheidt and the putatively fraudulent signatures on the documents at issue. It's been the rule in Ohio for a long time that handwriting comparisons are typically within the province of experts. So to compare an established hand to a putative one, you generally need to be an expert. For lay opinion on handwriting comparison, you can render those opinions if you have familiarity acquired for non-litigation purposes. Ms. Johnson's testimony was acquired as part of her investigation into a criminal case. So straightforwardly, it's not a lay opinion that can be offered under Evidence Rule 901(b)(2). To kind of illustrate that concept, we've cited the Brennan case out of the 5th District as well as the Cooper case out of the 8th District that talks about this dynamic. So for instance, an estranged wife can make handwriting comparisons, but police who are investigating fraud cannot. And Ms. Johnson is much more like that latter category than the former. Now, what the Cooper case out of the 8th District does get at is juries are, absent the aid of an expert, allowed to make handwriting comparisons for themselves, and where a witness's handwriting opinion testimony is equivocal, that's okay, or at least harmless. Here, though, Johnson's testimony was not equivocal, at least with respect to the victim's handwriting not matching his established signatures. And with regard to Scheidt, the direct quote was more equivocal, that they appear to be the same, but they were nevertheless elicited by questions about geared toward whether those signatures, quote, matched, to use the prosecuting attorney's language. That is, the state intended to use her testimony to make a comparison that was squarely for the jury. And I would submit that, understanding the Cooper and Brennan cases is not so much about performing a tortured kind of semantic analysis on what a witness says. It's why an opinion is elicited. So here the state asked her, do these signatures match? And the thrust of her answer was yes. If she were to, by comparison, explain that she believed the signatures to be similar as part of, a way of explaining her subsequent investigative conduct, I think that probably does come in, and it's not afoul of the evidentiary rules, or at least harmless. But again, here, those questions were, the questions that elicited her answers were about whether they matched. They were not questions that asked for equivocation. Finally, the state in its reply brief suggested that there was no prejudice in the admission of her testimony as such. They've raised a harmlessness argument. I would submit that, as we've outlined in our brief, that the state, at least in closing argument, relied heavily on the statements she made. So just to quote some of the choice passages of that closing argument, Ms. Johnson testified that Ms. Scheidt's signatures that she reviewed match. The victim's signatures that she reviewed matched, except for the forged document. So, given that reliance by the state, given that the test for harmlessness is whether the testimony is prejudicial, harmlessness beyond a reasonable doubt, and whether excising the offending evidence that the defendant is still guilty beyond a reasonable doubt, I would submit that the admission was not harmless. I see that I have about a minute and a half left. I've kind of reached the end of my planned remarks, so I'm happy to field questions, but otherwise would yield the balance of my time.
Thank you. Appearing there are no questions, thank you for your presentation today. On behalf of the court will take the matter in advisement, issue a decision in course. When that decision is made, the clerk will mail a copy of it to you and be available at the High Supreme Court website.
Thank you very much.